Hi everybody, it's Kirsty here. So I'm down in Manly at Australian Family Lawyers here with Danielle Forward. And Danielle has kindly given up her time to answer some of the questions that we had for her. So if you are going through a separation, or if you're thinking about going through a separation, these answers might be really helpful to you. You may have more, so if you do, please get in touch with Danielle and the team, and you can ask her your specific questions. But yeah, thank you for your time.
That's fine. Look, there were some great questions. So I'm hoping that, it can be helpful to some. There's obviously probably a lot more questions to unpack in all of them, but that's why we're here. If you do need any legal advice, always get in touch. We do offer that complimentary 30-minute referral call for Social Mums Club members. So certainly get in touch if you need. And if you want to do another Q&A, send through some questions. If we've got time, maybe we'll get back and do it again. All right, so question 1. This is a really important one actually, because when you're in a relationship and you've separated, there's time limits on when you can have a property settlement or apply to the court for property settlement. So here when it's, is there a cutoff period? Yes. And it's different for if you're in a de facto relationship or a marriage. So in a de facto relationship, it's generally 2 years from the date of separation that you have the right to a property settlement. That being said, there are cases where you can seek the court's leave to proceed out of time. So whilst there is a 2-year time limit in this case, I say that with a grey area of, maybe in the future. So it's always our advice to formalise your property settlement when you can. So there is a cost to that. You can do a call around, you can get a quote from a lawyer as to how much it's going to be. Just ask the question, what's the range, or is it a fixed fee? And what are the pros and cons of formalising it? But the only way to have that security and confidence moving forward is to formalise it. So get the advice, get the quote, know what you're going to be spending, and then formalise it. There's actually a lot of new options now. So in the past, it was obviously you pay the solicitor up front. That's generally what you always need to do. Some solicitors will work on a deferred fee basis. So that being that they don't get paid until the end when the client receives their property settlement. So generally speaking, the house will be put up for sale quite often. And then once the house is sold, debts are paid, including the lawyer. Not all lawyers do this. So there are now new firms that are called litigation funding services. So it's similar to a bank. It is a loan and it is interest on top of that loan, but it is specific for family law matters because normal banks generally won't give you the funds for that, or unless it's a personal loan, of course, and the interest rates, you get your own advice. But those family law litigation funding companies, we're seeing more and more, and they're quite quick turnaround as well. So if you need to get the funds to pay for it, that's a really good option. Otherwise, when you get your legal advice, have that discussion of, if you come on board, do you act for the whole matter in every single way, or do you act in the background, which is a lot of what we do as well. So it might be, the client will be managing all of the communication, going to court, but we're in the background to give that advice and to help them with that correspondence, rather than what we would call formally being on the record and then being liable for all of the work. So there's flexible options that you can work by just asking the question. And otherwise there's community legal centres as well that can help direct with certain documents to complete and the like. Number 3, relocation. So relocation matters are one of the most complex matters in our system. There's a lot of factors that need to be taken into account. The court won't generally order where parents live. They make orders as to where children live and what's primarily in their best interest. So if it's to live with one parent, where is that parent living, and how do we manage the time spending with the other parent if it's safe to do so. So first step is to get legal advice as to prospects of, what's the likelihood of the court saying that yes, you can move, and figuring out how to, start those conversations with the other parent. So then it would be, bring it up, ask, see, what arrangements could be in place with the move. We do see a lot of it because family lives in the other, state or jurisdiction, and it would obviously help that parent, care for the children. But that has to be factored in with maintaining the relationship with the other parent at a distance. So, and if that means varying the current arrangements, is that going to be in their best interests again? So get the advice, try and have some direct discussions with the other parent if it's safe and appropriate to do so, potentially go to a mediation, and then formalise any agreement that you do reach. So having those orders in place that say, yes, children live here and spend time with the other parent, and then you've got that court order in place. In the absence of any agreement or court order, really parents can do what they like. So there's a risk there. If one parent moves, there's little you can do. You've got to go to court and get a recovery order. So there's all these complications that can follow. But if you get that advice at the outset, then you can be better placed to have those conversations and mediate. Okay, well, this is a question for the lawyer that you're engaging. You should always have a formal cost agreement in place. So they should provide you with that, outline what the work is to be done, and usually arrange a low and a high with what's going to be done. If you're concerned that the work isn't necessary, we'll ask them, why are they doing that work? Just ask the question, see what the response is. As lawyers, we have a duty to try and resolve matters as efficiently and cost effectively as possible. So generally, if the lawyer's doing the right thing, they will only be doing the work that is necessary to do that. If you're questioning that, then perhaps you do need to get a second opinion. And really, if you've lost confidence in them in doing the work, or whether it's necessary, perhaps you do need to go somewhere else. Trust your gut. If you feel that it's not right, it might not be right. It's a lot of money. It's the most important thing you'll go through. Go somewhere else. It seems daunting, but you want to make sure that you're confident in your representation. Okay, so binding financial agreements are becoming much more popular. They're also what people call prenups, but it is a binding financial agreement, and they do work best in those second and third, relationships, where you want to have particular assets go to children of former relationships, or in matters where you do have an inheritance or expecting an inheritance, come in the relationship with more, so to speak. So we certainly do a lot of them, and we do advocate for them in the right scenario. Sometimes they're not right to do so. So again, you get legal advice as to whether you want to enter into it or not. But they could be useful in protecting those assets. Even if you have a binding financial agreement, is it going to be set aside in the future? That it is a little bit uncertain, but get the legal advice, and you have to before you enter into one anyway, and make your own decision of that. So question 6, so this is interesting. The court has a duty to sever the financial relationship of the parties. So couples then have to think, okay, well, this is our asset pool as it is moving forward. We've got to dismantle it, and so making sure that everything's in one person's name moving forward rather than joint. That's easier said than done because, financially, on your own, it might be hard to get a mortgage, to purchase something else and to get back on your feet. So we are seeing a lot more inquiries of couples sort of maintaining the status quo for a little bit longer, or jointly buying things and dealing with it later in order to maintain where the children live and that sort of thing, which is doable generally as long as you have a future end date and plan. With that, keeping in mind you want to sever that financial relationship ultimately. If you want to do it at a point in time in the future, then it's just a matter of thinking about how is that done. So it's not madness to think in this realm. It just requires definitely legal advice and a lot of thought of the pros and cons. What can happen in that interim period? If people get new partners, is that going to make it complicated? Is it going to sort of prevent one party from doing something else because they're attached to assets still? So it's actually possible. It's just whether it's best financially for either party, you need to get advice on. If you've got an agreement that you want to stick, you need to formalise it. So strike while the iron's hot. If this is the agreement as it is now, you want to make sure that that's going to happen in the future, then try and get it formalised as soon as possible. Because if you don't have a formal agreement, then anything can happen and people renege on the agreement, and again, going back to the court wanting to sever that financial relationship once you're separated, if one party really wants to do so, then that will generally be the course of action to some extent. But obviously a factor of not kicking anybody out onto the street, and if they're vulnerable people, that will take priority to some extent and that will be relevant. But if you've got that agreement now and you're concerned about that, sticking, formalise it and get, legal advice in order to do so.
That was amazing. So much good advice there. Lots to unpack. I think it's important to, like, Danielle's so modest, and she's just like, if you have a lawyer, go and see them. I would say don't just go to any lawyer. Definitely come down here, see Danielle and the team at Australian Family Lawyers here in Bayside. Well, they're in Manly. Because as you can see, she's super down to earth, super lovely, and she will make sure she does such a good job for you and your family. So thank you so much.
Thanks, Kirsty.
So if you want to book in to speak to Danielle personally, then they have a free 30-minute consultation. Yep. So what's the best way to get in touch?
Yep, so just contact the office. Hannah, our amazing legal assistant, will organise that initial phone call, do the initial conflict checks, book it into my calendar. I'll give you a call and we'll see if it's something that we can help you with.